Hi there, I'm Christine Van Gyn, and this is the Freedom Update, the new bi-weekly video podcast from the Canadian Constitution Foundation, where we talk about our ongoing cases, discuss interesting constitutional developments from across Canada, and update you about our upcoming events. Thanks for tuning in, and let's talk about freedom. Recently, we were in court, Zoom court, arguing a case about what the government calls fake news. Justin Trudeau's government recently amended Section 91 Sub 1 of the Canada Elections Act, which makes it an offence to publish certain types of false statements about political candidates and other public figures during an election period. This sounds like a good idea. I mean, no one likes fake news. But should it really be the government deciding what fake news is? And keep in mind, this applies to individuals, not just media outlets. In our view, the law is too vague and gives too much discretion to government bureaucrats. It prohibits certain types of false statements about candidates' education, professional qualifications, place of birth, associated groups, or criminal record or criminal investigations. But the law doesn't define what a false statement is. And if an unelected bureaucrat decides you've made one, you can get a fine of up to $50,000 and be sentenced to up to 5 years in prison. This even applies to so-called false statements about non-candidates. The law covers other public figures, individuals associated with a political party or candidate, but it doesn't provide a real definition. Could a campaign manager qualify? A pundit on CBC? A union leader? It's really unclear. And there are no carve-outs or exemptions, like for comedy or sarcasm. A joke on Twitter could land you under investigation, and it doesn't matter if you believed that the statement was true when you posted it. There's no room for error. So posting about Andrew Scheer being an insurance broker or Justin Trudeau being a crook could violate this law. While false information is a problem, it's long been a familiar and unfortunate feature of election campaigns. But even if democracy would be better off without false statements, it would be worse off with the government serving as editor-in-chief. With vague language and a lack of definitions, the legislation gives the election commissioner broad and unpredictable discretion over how the law will be interpreted and enforced. As the arbiter of truth, will the government act in a fair and impartial way? We don't want to find out. That's why we've challenged this law. We were in court arguing that the law is a violation of the charter-protected right to freedom of expression. Freedom of expression is a pillar of free and democratic society. Our charter right to free expression is content neutral. It protects statements that are popular as much as it protects statements that are unpopular, and it protects statements that are true just as it protects statements that are false. The uninhibited exchange of information, beliefs, and opinions about candidates, true, false, or otherwise, is essential to a healthy and functioning election process. Voters are entitled to decide for themselves which sources of information about candidates are credible and which are not. This isn't the role of government. The response to false information should not be for the government to sanction speech, but rather to promote media and information literacy among the population and to foster open discourse so Canadians can make up their own minds about who to vote for. We're expecting a result in this case in the coming months, and we'll be sure to keep you updated through our emails and our video updates. If you want to sign up for our email list, visit www.theccf.ca. There are some interesting constitutional developments across Canada, and this week we're looking at lockdown announcements from various different provinces and what that means for our charter-protected rights. Provinces across Canada are now in various stages of COVID lockdown, and I want to talk about some of the different approaches that are being taken and how these lockdowns impact our rights. First, there are some provinces with partial lockdowns. For example, BC, Alberta, and Saskatchewan. In BC, the government has ordered mandatory masks, but has limited social gatherings, closed group fitness, and has imposed restrictions on restaurants. Alberta has also restricted social gatherings, and it's also imposed capacity restrictions on both restaurants and retailers. Likewise, Saskatchewan has limited private gatherings, restricted capacity in retail stores, and banned team sports and group fitness. These 3 provinces are a partial lockdown, but others are in full lockdown, like Manitoba, which now has a 5-person gathering limit indoors or outdoors, and retail stores are shut. Big box stores are restricted to selling essential items from a government-approved list. Ontario is also in a similar lockdown, with strict limits on gatherings, including 10-person limits on religious services, and stores, gyms, and restaurants are ordered closed completely. Only big box stores are permitted to open, and they have capacity limits. Quebec is also under a lockdown, and it's the only province that's restricting public schools, with the Premier announcing an extended Christmas break. The Atlantic bubble, which permitted travel only among the Atlantic provinces, is now burst. It's on hold, with Newfoundland and PEI pulling out. Strict gathering limits of 5 people have also taken effect in Halifax, which now has closed restaurants, gyms, and churches. Capacity limits on stores have also been imposed. So what does this mean for our civil liberties? Are these restrictions constitutional? The Charter provides an explicit guarantee of our political and civil rights. It includes protection for freedom of conscience, speech, expression, assembly, and association. It protects the rights of citizens to enter, remain in, and leave Canada and travel between provinces. It protects the right to life, liberty, and security, and it protects our right to equal protection and benefit under the law without discrimination. So it's pretty easy to see how many of these rights are being engaged and violated by a lot of government action in response to the COVID crisis. For example, gathering restrictions implicate our right to freedom of assembly. Mandatory mask orders touch on our liberty rights, although minimally, and travel restrictions impair our mobility rights. Freedom of religion is infringed by the limits on churches, temples, and mosques. Business closures are a little bit more complicated. The right to carry on a business and engage in economic activity isn't protected by the Charter. It's a long-established common law right, but it's subject to extensive regulation. The right to life, liberty, and security applies to individuals. It doesn't apply to businesses. While many rights are violated by these government acts in response to COVID, the Charter has something called the Limitations Clause in Section 1, and this allows governments to justify infringements to certain rights. Controlling the spread of COVID is an important objective, and it's an objective that actually engages other Charter rights, including the right to life, liberty, and security. When balancing competing fundamental rights, courts will show considerable deference to government attempts to craft proportionate responses, and minimal impairment doesn't require the government action to be perfect. However, even with wide leeway from the courts, some government action may be taking things too far. It may not be minimally impairing to have multiple restrictions heaped on top of one another. This is especially true for the provinces where there are total prohibitions on openings. Why close things down completely when there's already a requirement for masks, sanitation, and limiting entry would achieve the same goal? Why limit travel between provinces when quarantine is already required? Moreover, limits to our rights can't be arbitrary, unfair, or based on irrational considerations. And many government actions are now treading into the irrational and arbitrary territory. Why close theaters or churches when everyone faces the same direction in a large room? No one talks, everyone's in a mask, and there's an absence of any COVID spread in theaters. Such a measure seems more about political optics than it does about science and public health. But legal arguments aside, the government needs to provide a rationale to the public for their measures. And right now, very little information has been provided or disclosed about where transmission is really taking place. Yet all of these limits have been imposed on gatherings and businesses. Even if the government COVID measures were to survive a legal charter challenge, they may lose public support if the government doesn't provide evidence now. Instead of sharing upcoming events this week, I have a cool offer for all our viewers. I've written an ebook about how the government response to COVID is impacting our civil liberties. It's called COVID and Freedom, and right now it's available totally for free for download on our website, www.theccf.ca. The book talks a lot about the things I just outlined: mandatory masks, business closures, gathering limits, and privacy rights. I encourage anyone who wants to know more about what this once-in-a-generation challenge to our civil liberties means to download it. That's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.